seat, please. Next case is Kelly versus Kelly, or Purpura versus Kelly. Mr. Jones.
Thank you, Your Honor. May it please the Court, I'm Michael Jones from Orlando, Florida. I respectfully request to reserve 1 minute, Madam Clerk. I represent the appellant here, Jolene Kelly, the wife in the trial court below. We're bringing to the Court 3 procedural issues and three substantive issues and one additional issue that procedurally impacted upon the first issue. We're asking the Court to reverse the decision of the trial court in 3 areas and remand for further proceedings. The first issue that we're bringing before the Court is the issue of the denial of the request by the wife for permanent alimony, by the appellant for permanent alimony. We are not here in a last-ditch, desperate effort to try to have this Court reweigh the evidence. Obviously, that is not the function of this Court and not what it does. The trial court below took the one piece of evidence, the evidence from one doctor who never observed the appellant, never observed the wife, never observed her medical records, never treated her, never diagnosed her, reached an opinion. And while there's
But his opinion, Mr. Jones, didn't really deal with her diagnosis. His opinion dealt with the condition that your expert claimed that she suffered from.
That's correct. It became a labeling.
I mean, we can pretty much conclude that his opinion concerning this particular condition would not have changed had he examined her, because he conceded for purposes of discussion that her symptoms were real.
That's correct, and that is exactly the point that I tried to make in the...
What difference does it, I guess my point is, what difference does it make whether he examined her or not, or reviewed records or anything like that?
Well, it gives him a little less knowledge of this particular patient and her particular symptoms. But even in his discussion while saying that this particular condition, fibromyalgia, did not exist as a medical condition, he admitted that all the symptoms existed and admitted that all the symptoms of this particular patient existed and that she did suffer detriment as a result of them. But even putting that aside and acknowledging that the trial court, as flawed as this evidence was, and which was exacerbated by the improper use of an excerpt from a federal court case discussing my expert witness, even putting that testimony aside and acknowledging that the trial court does have the right to accept that testimony, the court did not consider the other evidence that was essential and critical to the wife's claim for permanent periodic alimony. The court in the first district in the Jacques case requires a specific finding of the various alimony factors under 6108. There was no findings. I detail in great length in my initial brief the various aspects that were not considered, the overwhelming other medical evidence that was uncontroverted of the wife's condition that prevented her, the appellant's condition that prevented her from working full time, the resulting disparity in income, the very long-term marriage of 24 years, of which there's a presumption in favor of alimony. The difference.
Well, now, does that? I mean, we all know about the 20-year, 25-year presumption, but does that have any effect where both parties have, arguably, I realize this is not your position, but does that have any effect where both parties have similar earning capacity?
Yes, Your Honor, it's a factor. The court would, and that's.
So if my wife divorces me tomorrow, there's a presumption if she gets permanent alimony?
No, of course not, Your Honor.
I'm telling you what she does for a living, but how could there be such a presumption?
The presumption is clearly stated in the case law, but it is not a controlling presumption. It is rebuttable.
But that presumption, doesn't it presuppose, though, a vast disparity in earning?
No, Your Honor, I don't think so. I think that that's another factor that has to be considered respectfully.
Well, then if that's the case, you've got a constitutional problem with your argument, because the presumption would run toward the husband as well as the wife. If it doesn't presuppose a vast disparity in earning. Implicit in your argument is that this favors the wife.
Yes, Your Honor, in this particular case it does, because she is the claimant. In another scenario where the husband might have other factors that would be arguably in favor of alimony, that he as well would have a claim for alimony. It is one factor. It is not a controlling factor. And certainly the court then would have to find disparity of income and certain other factors involved in it as well.
Well, counsel, where we have a record that on its face, for purpose of our argument, clearly reflects that the wife who is claiming permanent periodic alimony has comparable earning capacity and indeed is employed, and the record reflects that she can be employed full time at the same earning capacity. Is why is that not sufficient to deny alimony?
Your Honor,
He's going to need an ability to pay.
Your Honor, respectfully, I'm not sure that that's exactly what the record shows. I concede that the record
Let's
shows...
assume that it shows that. Would that not be sufficient to make no other findings?
Your Honor, if there's comparable income, certainly it makes the alimony claim much less strong. Absolutely. But to address the issues that you have raised, while there is a finding and a clear record that they make the same hourly rate, the wife, by her testimony and the records from the employment, showed that she was only working approximately 20 hours a week, approximately half-time, as a result of her medical condition. There was testimony that there were full-time jobs available, but there was no testimony that she could do those full-time jobs. That's the difference, and that's the distinction I would respectfully submit, Your Honor. We also have raised several other questions before the court. One is an issue of equitable distribution. The husband, at the time of filing the dissolution of marriage, which would be the valuation date, had accrued approximately 183 hours of deferred compensation time.
Before you get into the specifics of the that's leave time, isn't it? Vacation time? Or?
It's leave, vacation, and sick. Yes.
How do these two folks look in terms of their financial affidavit when you look at their net worth?
When you look at their net worth, which is another alimony factor, Your Honor, the husband has been able to take the assets of the marriage, preserve them during the time of the trial, and in fact add to them and enhance them. The wife, on the other hand, because of her lack of earning capability, her medical conditions, and her inability to work full-time and support herself, has had to not only spend her assets that she acquired in the equitable distribution, but incurred over $20,000 in additional debt in a period of 1 year time. So that's another alimony factor.
This was between the time of the filing and the final hearing, though.
That's correct, Your Honor.
That those assets were depleted.
That's correct, and that is, we did not ask at trial for that to be awarded,
right,
and because it clearly was post-filing
debt.
But it shows,
though, if you looked at this couple at the time of filing, or whatever date we're going to use under 61075 to identify marital assets, that the equitable distribution was fairly equal at that time. Would you not concede that?
Absolutely, except for the one factor that I pointed out that there was incorrect about the 183 hours.
I'm happy to have you argue that, but I just wanted that sort of predicate.
Absolutely.
Fine.
We have no argument with the equitable distribution. There was a marital home with a small amount of equity. They sold it. They split it themselves. There was a relatively small savings account. Honestly, I don't remember. I think it was in the $10,000 range. They each got $5,000, $7,500 from it. We have no quarrel on the equitable distribution, other than that one particular point that we do raise in the brief, which is there is a definite 183 hours of accrued time, of which, admittedly, the husband could only cash in at that moment a certain portion. I believe it was about 30 hours of it, and that's all the trial court awarded. But the rest of those time, although the husband couldn't get to it immediately, were, in fact, his asset and his property, and he would get it at some point. It's extremely analogous to what this court does all the time of dividing military pensions. 12 years into a marriage, 12 years into the military, they get 1/2 of 12 20th.
That comes out in terms of dollars. Now, suppose that the man decides that he simply has to take a break and his employer says, you need to get away from this work, you ought to need a vacation. He takes off for 3 months and then he comes back to his job. And he has 0 in terms of accrued leave time. There is no... All he's getting is his regular compensation during the period of time he's on leave. There is nothing to distribute, is there?
Yes, Your Honor, respectfully there is, because it's exactly what you said. He can take that at any time. He can take that leave of absence. He can quit that employment and take those 180 hours and cash them in. They are a definite asset that exists that accrued during the marriage. It's deferred compensation.
He cannot simply go on vacation and then come back to his employment.
He could, absolutely.
But then at that juncture, there would be no value attached to it.
But at that juncture, that would be post-petition and his action. It would be analogous if he had a share of Coca-Cola, 2 shares of Coca-Cola stock, and after filing went and cashed them in and spent the money in Las Vegas. There's still an equitable distribution, although he has used up the particular thing, and he owes her 1 share of Coca-Cola stock. It would be...
So basically, your argument is that she's entitled to half of his vacation.
No, because it's leave, it's accrued leave, it's earned during the marriage. So yes, she is entitled to it. I'd like to reserve whatever time I have. I think it's about 30 seconds.
Thank you. Ms. Swanson.
Thank you. Good morning again. I'm Cynthia Swanson. I'm appearing for the appellee, and I appreciate you allowing me to file my notice of appearance rather late in this case and come in. I wanted to respond to a couple of the points that Mr. Jones was making, and if I could mention the last one first, the paid leave. One of the things I'd like to point out about that case is there are only two cases that the parties have cited to this court as authority for whether or not the paid leave is a marital asset. Neither of those cases is really on point with this one, and I wanted to talk about them just briefly and distinguish them.
Let me ask you, though, how could, under 61075, how could paid leave, which is vested, even though you can't convert it to cash right now, it's vested right, how could that not be a marital asset?
I'd like to know how you're going to value it if you can't cash it in.
Well, you know, we dealt with that with unvested pensions many years ago because lawyers argued for years, you can't value a non-vested pension. You may have made the same argument. I don't know.
But this is a little bit different than a pension, in my opinion. A pension is there, and you're going to get it no matter what may happen to you.
Well, go back to my question, though. How can you argue as an advocate that under Florida equitable distribution law, there's no question that this was accrued during the marriage.
That's correct.
That it was accrued attributable to marital efforts because the husband's work is all 100% marital efforts.
Yes.
How do you argue it's not a marital asset? I'm not asking you to concede that she's entitled to it, but how do you argue that it's not a marital asset?
I think it is a marital asset that has no value at this time, and because it has no value, then I don't think that you have the ability, the trial judge doesn't have the ability to essentially reserve jurisdiction ad infinitum to see whether or not the husband may at some time in the future cash it all in and get a bunch of money.
And were he to get sick?
Exactly. A break a leg, I think, was the scenario mentioned in the brief. If he breaks his leg, if he gets sick, if he has to take sick leave, if he has to use it in order to support himself, then it's used up. It's too speculative.
What's the difference in that and a 401k that has an IRS exemption for emergency medical bills? Why shouldn't he be able to save his 401k for when he gets sick? You wouldn't let him do that, would you?
No, I wouldn't. It's different because he could cash in that 401k. There might be penalties, taxes, and so on, but he could go get money for that 401k if he had to. For this sick leave and vacation leave, he cannot do that now. There's no possible way for him to do it. And I think that's just too speculative, and you're asking for a trial court to reserve jurisdiction for too long to come back and later say, oh, well, let's go back 10 years and now we'll figure out what you should have paid her. I wanted to also mention and respond to a couple of things Mr. Jones said about the experts, the two experts. And Judge Barfield, I think you brought up the point of the fact that Dr. Ehrlich, the husband's expert, had never, what did it matter whether or not he had ever seen the wife. And the one point I wanted to make is, remember, the trial judge saw the wife. And that's what we invest trial judges with the authority and the duty to do, is to observe the witnesses there, to see their body language, their tones of voice, to evaluate and weigh all the evidence that's before them. The trial judge in this case had the opportunity to see the wife through two trials, to see the wife and the husband and their witnesses, to get information, actually more than most trial judges do have. And when the trial judge has two opposing experts who have two opposing views, we say to trial judges, you're not supposed to split the baby here. You're not supposed to find the medium road. You're supposed to say, which witness do you believe? Which witness is more credible? Which evidence has more weight to you? That's what we ask trial judges to do, and that's what the trial judge did in this case. And as the appellate court, you can't come back in and say, well, gee, if I had been the trial judge, I would have looked at it a little bit different way. In this case, the record upholds everything, all of the rulings of the trial judge. As to the fact that the trial judge didn't go through in a final judgment and say, according to this factor, say the different ages of the parties, I make these findings, or according to the health of the parties, I make these findings. It's true the judge didn't go through and make a lot of findings, but the record substantiates the findings and the rulings that the trial judge did make. And I think the fact that I'd like you to be persuaded, particularly by the reasoning in the Broadfoot case, which is a third DCA case from 2001, which talks about reversing for failure to make findings only if the lack of findings frustrates your ability to actually review the record. In this case, the record has substantial amounts of information about the wife's earning ability. She has equal earning ability to the husband. They have a few cents difference in their hourly wage. There is full-time opportunity for her to work. She did say she could do those jobs. If you recall in the record, she was questioned as to her evaluations, and in her evaluations it said, here are job requirements, lifting so much weight, being on your feet so long, and so on. She signed those evaluations and said she could do all of those things. She can do those full-time jobs. In this case, the trial judge had the information before him that would lead him to believe that she could do the work. An expert witness who says she's gotten bad medical advice, she needs to get out and work and focus on things other than herself. The judge gave her some bridge the gap alimony so that she had the ability to set up her own household and so on after they separated. And with her ability to earn exactly the same amount of money as the husband, and with the exactly equal division in assets that the parties themselves agreed on, the wife is in exactly the same position after their separation as is the husband. Mr. Jones talked about the fact that the husband was able to preserve the assets that were distributed to him, whereas the wife had to spend some of her assets. Well, that's because she wasn't working full-time. There is no presumption that just because this is a long marriage that she gets alimony if she's not working full-time. The judge has to go back to that need and ability to pay standard. And on the need standard, he has to look at what are the abilities of the parties to earn income. She's been employed full-time in the past. She has the same ability to earn income that the husband does. She's in exactly the same position on assets. And in that case, there's just no reason to award any alimony to her. I think I'm just going to mention real quickly, since I have a little bit of time, the one issue about whether Judge Smith, the trial judge, allowed the expert to talk about a document that wasn't in evidence. Although the wife's counsel didn't stipulate to the document coming into evidence, when the document was actually referred to by the witnesses, he never objected. And so the two attorneys had talked beforehand, made a lot of stipulations about documents coming in at evidence. I think you saw the trial judge at one point thank them for the professional way in which they had handled the case. When this one document the husband wanted to bring in, he didn't stipulate to it coming in, but then when it was referred to, he never objected. And the fact that he didn't object means he can't appeal it to this court for the first time now.
You were going to, I think, go ahead and distinguish that, this is back on the accrued but unpaid leave. You were going to distinguish the Brotman case.
Yes. Oh, thank you.
I'm cut you off, but I want you to do that.
Right. In the Brotman case, this was the 4th DCA case. In that case, the husband who had the accrued leave had actually already been terminated from his job at the time they got to the point of valuing the asset. So he already actually had the cash. He received a severance package, and part of it was pay for his accumulated sick leave and vacation leave. I think that's a completely different situation. He actually had the cash. In our case, this husband is still employed, still may need to use it, doesn't have any ability to get any cash for it, and that's this distinguishing point. In the King case, which is a 5th DCA 1988 case, I don't think we can use this as very good authority because it's very unclear as to what happened. The husband testified at trial that he had accrued around 1,500 hours of paid time off, but that he could only cash in 700 hours. And then the court actually says counsel figured how much it was worth. And I don't know if that was the husband's counsel or the wife's counsel. I can't tell from reading the case. So I don't know if that means the husband was saying, oh, I agree that it's worth this $15,000, or if that was just the wife's position. And then the appellate court remanded that back to the trial court to take further evidence and make a ruling. So I don't think the King case really has any authority for us in this situation at all. And with the Brotman case being completely different, it's not really any authority either. Those are all the arguments that I had to make, unless you have any questions. All right. Thank you very much.
Please, the court. Counsel correctly states that the Broadfoot case does have the situation in which the distribution had already been made. However, the case that the appellant relies on, which is the Gillian case specifically, is a situation where the husband is still employed. The Gillian court says the distribution of the cash value of leave balances upon dissolution of marriage has been deemed proper in several cases. If distribution were postponed to the time of retirement, husband would have discretion. The valuation that counsel objected to is very easy. You multiply the hours by the hourly rates. He had the cash available to pay it. It should have been valued and distributed at the time. I see my time is up.
Counsel, let me ask you one question.
Yes, sir.
Let's assume that we find validity to the argument regarding leave time. Why would he have to pay cash before he's entitled to collect cash for it?
That's exactly the
Why
same.
in the world, would it be possible, would it be within the jurisdiction of the trial court to order him, should he in the future convert the accrued leave into cash, he would pay 1/2 of that amount up until he had consumed the amount of accrued leave at the time the petition for dissolution?
That's exactly the question that the Gullian case decides, and they say that that would be an opportunity for the husband to frustrate the judgment, and rather than sow the seeds of future controversy, it was entirely appropriate to count the cash value of annual leave, compensatory leave, and sick leave balances as a marital asset and distribute it now. And I think that's the proper thing for the court to do.
Would you not have to discount the present value and discount also the probability that he would not collect it?
No, sir, because first of all, on the second point, there is no probability that he would not collect it because he will get it one way or the other. He'll either take that 3 months leave, he'll take the sick leave, or he'll retire and resign from that company and get the money. On your first instance, it's not a discountable event on future value because it is immediately convertible to cash. Are there any further questions? Appreciate the court's indulgence.